Marcantel. Hey, everybody, this is attorney Andy Marcantel. There it goes. Okay, the microphone just turned on. We got attorney Rachel Moss here.
Hello, everyone.
Happy Friday, YouTube, and welcome to another Attorneys on Retainer live stream. How you doing today, Rachel?
I'm doing good. I am so excited today to dive in and talk all about our experience at the NRA National Meeting.
That was so much fun.
It was such a blast.
Yeah, we just got back, and it was amazing last weekend. I actually think that our staff may have prepared a highlights reel that we haven't seen yet.
I think we got to check it out.
All right, guys, you want to roll that highlights reel? Hey, that's awesome. Nice work, guys. That was amazing. Yeah. Wow, what a fun time that was last weekend.
It was so good. That really takes me back. I felt like at the meeting, we got to have so many great experience. We did a podcast there. We have a lot of cool episodes coming. And I'm thinking back to all the really great people we interviewed.
I had to write down the list because we did so many podcasts, Rachel, that I forgot everybody. But we've got these coming out very soon, guys. We're getting them all edited up for you. Do you remember our first podcast was with Yehuda Reamer, also known as the Pew Pew Jew? That guy's hilarious. We had such a fun time with that guy. He has some really cool books and all kinds of cool projects he's working on. We met with Austin Kilmer from Core Dynamics Firearms Training, which is awesome because they're a local business here in Chandler, and they actually came and did a training for our firm.
Yeah, it was really cool. I actually was one of the people that got to train with Core Dynamics. I can say it was an excellent training. I'm really excited for our viewers to get to see this video in particular because it's one of the first times we've really had a video that kind of covers the other side of gun ownership. We talk all day long about the legal side, and in this video, you get to see some practical information as well about being a gun owner.
Yeah, absolutely. Another cool guest that we had was the representative Christian from Dead Air Silencers. Dead Air Silencers is an awesome company, and they're also going to be helping us sponsor our conference that we're going to be talking about in a little bit, our first annual Attorneys on Retainer conference.
Coming up in November.
Super excited about it, absolutely. So Christian's going to help us out with that. Isaac Demarest, who is an NRA board member. We had a pretty juicy conversation with him. I remember, Rachel, when we announced that we were going to be part of the NRA conference and that we were going to set up, I remember the reaction from a lot of people, like in the YouTube comments, was kind of mixed, right? The NRA's had a lot of controversy, especially in recent years. And, there's some arguments that it's not nearly the, once respected organization that it used to be. A lot of it has to do with corruption in leadership. Obviously, there's been some pretty public court cases. And they might be trying right now to go through a bit of a paradigm shift with their organization. And that's definitely the impression I got when we spoke to Isaac.
Yeah, I agree. I'm rooting for them right now because I think it only benefits us as gun owners to have another good advocacy organization out there. I am a little unhappy with some of the NRA's decisions in the past, specifically in the leadership. But according to Isaac, they're working on turning it around. I want to give them the benefit of the doubt right now, but I also want them to know our eyes are on them right now as they make these changes.
Yeah, I feel like you're like kind of a lifelong fan, and I remember when we got done with that, you're like, I think I'm gonna come off as like I'm super pro NRA in that. I did my best to kind of poke a little bit and prod and try to get to some of the heart of the controversy, and I think Isaac was like a super good sport about it and
I agree.
addressed it and wasn't trying to sweep things under the rug. There was never a time in the interview, with exception of maybe one or two times, where he's like, I can't answer that question. I thought he tried to be pretty open about it. But then on the flip side, after that, we had two awesome podcasts in a row with different people involved, including the Texas State Director from Gun Owners of America, who have kind of poised themselves in some people's minds as kind of like a direct competitor with the NRA in recent years.
And I found it interesting. We got different ideas from both people we talked to with GOA.
Hmm.
One took the position kind of similar to mine that they want to see the NRA recover and they think it's good to have multiple gun organizations out there advocating for people. And then the other person we interviewed had some words to say about the NRA. I'm not going to spoil it, but they had a slightly different opinion.
So, with regard to those particular interviews, because we had so much interest from our clients, from our AOR subscribers and clients, we're going to make those AOR exclusive. So, if you're already a client, keep an eye out for the email blast that we're going to do once those are all edited up. Joey and our staff is hard at work editing and chopping and getting all those videos ready. But we're going to send out the little dichotomy about the NRA kind of versus the GOA to our AOR clients. So stay tuned for that. You know, one of my favorite guests has got to be Lily Tang Williams. Lily Tang is amazing. Like, I had such a fun time during that podcast.
Yeah, she was the big surprise of the day for me
Me too.
because she was so energetic. She was ready to hit the ground running. And she had a lot to say because she has a very unique background. She actually grew up in communist China under Mao. And she gives such an interesting perspective on what that's like and how we might see some of that creeping into the United States.
Yeah, and she actually had to lie to get here to the country. She had to lie to her government
Hmm.
under false pretenses in order to escape that environment, get here to America, and then she never looked back. And she is shocked right now the direction that the country is going when she sees, having just fled from communism and this type of a government, seeing what's going on college campuses right now. She had a lot to say about that. But she's running for Congress right now. We were warned ahead of time. She's a pistol, and she definitely lived
Was.
lived up to that. So yeah, I can't wait to release that one. And then if you guys really want to see us kind of geek out on the legal side, we had our awesome last podcast with David Lombardo, who is a use of force expert and has been for years and years and years. And he's got an awesome life, really, really interesting guy. And I thought that was a fun podcast, too. He's really funny, too.
Yeah, I think there'll be some unexpected moments in that podcast because he's an expert witness, but also a former stand-up comedian.
Right, yeah.
Yeah.
Yeah, he's super interesting, guys. So, yeah, stay tuned for all those podcasts. We can't wait to release them. So, our marketing team has got a list of things that they want us to hit for them. And one of those things is that we want to talk about upcoming events. We want to talk about new merchandise that we have. But before we move on to that, I think it's just really super, like, just to share a few moments that I really enjoyed about the NRA National Conference. We met a ton of our AOR clients, and it was awesome, meeting so many of them in person. We had a number of people say we came to the conference just to meet you guys. We had a number of people. It was fun. We were answering legal questions all day, people coming up and asking all kinds of different scenario questions and all kinds of different things. And it was just a lot of fun meeting people.
Yeah, that was really special for me because this was my first trade conference I've been to, and it was actually ARR's first national trade show that we've gone to as a booth.
Right.
And meeting clients was so fun, and we're attorneys, so we actually like doing our job and we like answering legal questions. So I found it really fun just to meet new people, hear what they had to say, and if I could answer a question, answer a question.
And we had a box there that was like, if you want a question for an attorney, and they're not here at the booth, or they're doing a podcast or something like that, drop it in this box, and we'll answer it on our next live stream. So stay tuned, guys. Very soon we're going to be answering a bunch of those questions towards the end of today. But it was just really cool to meet so many people. So next big event for AOR, we've got the GOA is putting on an event in Knoxville in August.
Yeah, and I think this is going to be our opportunity. We'll have been to the NRA, we'll have been to the GOA, and now we really get to settle it. No, I'm kidding.
No.
But we're going to be at booth 705 at the GOA conference, and it's going to be really cool. It's a pretty unique conference. It seems like there's going to be some time for media, some time for range, and then also a ton of really cool exhibitors that GOA is going to put on.
Yeah, I think it's called the Goals or Gun Owners Advocacy and Leadership Summit. So that's going to be really cool. I know that we're working on getting like a pretty big podcast set up on that. We want to get a ton of guests and, be able to interact with our clients and everything like that. So I'm super excited for that. That's August 17th and 18th. come on by the booth and come on by the podcast shoot and say hi to us. We'd love to meet you, answer all kinds of legal questions, and yeah, we'd love to meet you down there. Merchandise updates. They want us to plug these new T-shirts.
We got to do
Shall
it.
we? Okay, I'll get mine. These are pretty cool. Check this
These
out,
are
guys.
brand new. I've got your 6.
I've got your 6, folks, and they come in a number of colors. I think we even have more colors than this. But that's the back of the shirt. On the front, they got a very simple logo. I know a bunch of people, too, have asked for like a shirt with just like a very simple logo, so we have that available as well. Also, we got patches.
So we have this really cool one that just says attorneys on retainer. It's got our logo. You can throw this on a tote bag, anything you want. If you go to a conference, throw it on your badge. It's perfect for that.
Yeah, really cool. Yeah, I saw that people were putting them on like tote bags and their jackets and stuff like that, which was really cool at the conference. It says here, possible hats. Team, do we have hats or do we not have hats? I think somebody said that we have like prototype hats right now.
Yeah, and we're getting to have some fun and like try them on and decide what's the best. We only want the best for you guys, so
I
I'm
think
really
we
excited.
line up the hats and have like people vote on the hats like in real time. Maybe like as the hats live stream where we just set up hats across the table and see what people like. Sometimes you just gotta,
I
put
love
it
it.
in real time.
Democracy, let the people decide.
Absolutely, I'm all about it. And then we have a note here because, frankly, all this stuff we started making all this cool merchandise because you guys asked us to. Our marketing team wants you guys to throw down in the comments what type of merch you would like us to make, and cool slogans and stuff like that you would like us to include on T-shirts and hats and mugs and whatever else you want. If we think it's a cool idea, we'll give you credit for it, and we'll send you a free piece of that merch once we get it all set up. So if you want to see your idea become a reality, feel free to either message us or shoot it as a comment down below. I think we've hit all the merch points now. Inaugural AOR convention this November. Rachel, are you excited for this?
I am so excited. I think it's going to be really cool for all of our members to get to see each of the attorneys at the law firm, get to go on stage, talk to them about current issues. I'm really excited to give my speech. I'm not going to spoil it yet, but it's going to be good.
Yeah, I know we've already had a whole bunch of people sign up for the conference, which is really cool. People from all around the country. And it's a 3-day event. It's going to be the first day is kind of a tour of the law firm. You show up, you can come and hang out at the law firm. We'll take you around. We'll introduce you to the staff. That's going to be really cool to have competent gun owners walking through our law firm, meeting the team, learning who's going to be representing them in their criminal case if, heaven forbid, they should ever need our services, answering all their legal questions and, putting their mind at ease and whatever they want to address with us. I'm really looking forward to that. Also on that day, we're going to have a little cocktail hour, I believe, after that, and that's going to be a lot of fun. Then the next day is kind of the big conference day. It's like kind of where all the speeches are going to be. We're going to give talks. We're going to give little workshops. We're going to have sponsors there. There's going to be vendors and everything like that. We're going to provide food. We're going to provide all kinds of different fun things on the conference day. And then on the Sunday of that weekend is going to be the big firm range day. And this is going to be really cool. We actually talked to one of our podcast sponsors who was there about what's going to happen on that day, but a bunch of different silencers companies are going to be coming out and setting up like, hey, come try your gun with one of our silencers. We've got some guns you guys can fire, hear it before and after the silencer. There's all like, what a cool like concept for them to, show off their product at the same time and educate people on silencers, suppressors, and similar products.
I think it's very exciting because I talk to a lot of gun owners that have never had the opportunity to shoot with a silencer. So I definitely encourage people to check out that day. We're going to be partnering with Healy, America's firearm provider, for that day as well. So we're really looking forward to it. And I think we forgot to mention that if you are an AOR member, you get a free ticket.
Oh, yeah, that's a really
How can
important
you pass
thing.
that up?
Absolutely. And so the dates for that are Friday, November 8th, 2024 through Sunday, November 10th, 2024. So if you haven't reserved your spot, make sure to go to events or email events@attorneysonretainer.us. We sent you guys all out an email blast that has some information about how to sign up for the conference and join many competent, responsible, awesome gun owners from all over the country and the attorneys for freedom, and we will have a wonderful weekend. So I'm really looking forward to that.
Me too. Well,
I,
I think it's time to dive into our
I think
questions.
it's questions time at long last, and this is kind of a mix of different sources. I'm being told we got the questions from the little drop a question in at the booth box. We got actually some call-in questions, clients calling in and asking us to answer these things live on the stream, and then some YouTube questions. So, guys, why don't we start busting through those questions? What do you got for us? All right, first we got Donnie. Do you cover Puerto Rico? And the answer to this question is currently we do not cover Puerto Rico or any of the other territories. And the reason is there's different rules regarding Pro Hoc Vice admissions in those different jurisdictions. But there have been a surprising amount of people who have asked us this question.
Hmm.
And whenever, like every other feature we've added to this program, whenever there's a surprising amount of people asking us for a feature or for, the same reoccurring question, do you guys cover this? Our brains start moving in the way of, well, we got no excuses if we want to have the best product on the market.
Hmm.
So stay tuned, guys. We have listened to you, and we have some things in the works that we're not ready to announce yet. But thank you for helping us to continue to improve our program, and we got some things in the works. So stay tuned on that one. All right, let's see what they got next for us.
Okay, our next question is from Paul. Should I take traumatic medical training and will it get me sued?
Wow. Okay. Well, there's several different ways we can go with this. I think it's really interesting that we were talking to on our podcast last week, and we were talking to Austin
Hmm.
from Core Dynamics, and he's a firearms trainer.
Yes.
But he doesn't just train people on firearms; he trains people on medical care and emergency medical
Yeah,
care.
I think his way of thinking is that if you're able to put a bullet in something, you should know how to plug that hole as well.
Absolutely, yeah, and
So,
that's fair. And he was a strong advocate because I think it came up on the podcast,
hmm.
and he was saying, absolutely, like if you're dead, if you don't know how to treat your wound, if you get into a gunfight with somebody and you're dead, then that's worse than having an adverse implication in a criminal case potentially. And I think this question might be coming up because I think there are some other podcasters who are talking about implications that prosecutors can attempt to draw if somebody has background in training, or that it can come up in civil liability
Hmm.
that, well, you had higher levels of training, therefore we're going to hold you to a higher standard kind of a thing.
Yeah, because I don't love the idea personally that we should be discouraged from doing good medical training that could help us in a dire situation just because we might get sued. My attorney mind is turning, and I think I could argue because you've received a traumatic medical training, then there should be a presumption that in that instance when you were providing medical care to either yourself or someone else, that you were making the right decisions because you have been trained, that it's more likely you were making the right calls in that situation because you had that training.
Hmm.
But because of this, we're asking our civil attorney, Pierre, a great civil attorney, to really look into this issue for us, do some research, because there currently is just a lot of controversy, even among attorneys, about whether or not you should do this training and whether or not, if you get that training, it's putting you at a higher risk of a lawsuit.
Right. Yeah. This is really in that civil realm, and we're criminal defense attorneys.
Hmm.
But we have an excellent civil department who we've talked to, and he's excited about working on this project. So, right now, though, without like seeing what the case law is and how many cases practically in the real world have actually turned on this issue, generally speaking, I err on the side of exactly what you just said, which is we have to live our lives in smart ways. We have to
Hmm.
live our lives in ways that are beneficial to us and the people around us, and not in fear, right?
Hmm.
And I think it's unreasonable to miss out on something as important and potentially life saving as medical training because you're worried about, the prospects of an adverse proposition in a civil case. That ain't enough to me. And so, I mean, unless I see some really compelling evidence that there's a slew of civil cases across the country where this has been really adverse to civil defendants in gun cases, my gut reaction is to say you should get the medical training. I tend to agree. In other words, I
Hmm.
tend to agree with our podcast guest that we spoke to at the NRA.
Hmm.
All right. What else you guys got for us? One from Brad. Brad asks, may I legally carry at a church service that has services at a school? Well, it depends upon the school. I guess the simplest way to kind of frame this question is it doesn't matter what the purpose of the gathering is at the school. It doesn't matter whether it's a church meeting. It doesn't matter if it's you're going there for some sort of an event or sporting event for the school. If you're going to a school, then whatever the school's rules are. And if the school is a gun-free zone, you're not allowed to go no matter what the reasons are. Your right to practice religion enshrined by the First Amendment and your Second Amendment rights, those things, they're not mutually exclusive, but at the same time, they don't cancel each other out. So
Hmm.
the preferences of the school is going to override. I will say, though, very important point that if you are an attorney's on retainer client and you have to act in self-defense, we don't care if you're in a place where you weren't legally allowed to have the gun. We don't care. And if you use your firearm in self-defense in a prohibited place, it doesn't affect in the least bit our analysis of coverage. We're still looking at whether whether it was justified and whether we can prove our client's innocence, whether we can prove it's a good shoot, without the least bit of thought of what the government currently says is a place you can't carry your firearm.
I say this all the time. We're a law firm. We like these tougher cases and
Yeah.
these gun-free zones. But I do want to add that as a responsible gun owner, it is smart to know where you're allowed to carry a gun or not. I'm not a fan of gun-free zones, but educate yourself, look into if you're interested in carrying at a school that happens to double as a church maybe on the weekends. Know if that school's a gun-free zone and then carry responsibly from
Yeah,
there.
couldn't agree more. All right, let's get another one up there, my friends. Anthony, if there is a size disparity and or multiple threats, can I proactively defend myself using deadly force? What is a scenario where I would be allowed to use deadly force in this situation? This is a great question. And this is a question that we talk about all the time because whenever you're analyzing, and if you guys haven't seen our most recent video, Mark and I did a recent video on reasonableness. And really, this question is just a question of reasonableness. Whenever you're describing a hypothetical scenario to an attorney and saying, hey, can I do this? Can I do that in this situation? All you're really asking us is, what is a hypothetical jury of my peers from the jurisdiction that this incident occurs in going to think is reasonable? That's it. That's the whole ball of wax at the end of the day. And so, while there is typically a bright line rule that you have to act proportionately with the
Hmm.
amount of force that you're using, in other words, as I've heard prosecutors say before, you can't bring a gun to a fist fight. You can't use deadly physical force in response to ordinary physical force. There are many situations where enough ordinary physical force, perhaps if you're outnumbered, perhaps if you have a pre existing medical condition, perhaps if there are numerous assailants, can all add up and equal deadly physical force.
Yeah, so in other words, size disparity and facing multiple threats are just more factors a jury needs to take into account when determining whether your actions were reasonable. At the end of the day, your use of deadly physical force also has to be in response to an imminent threat. So if there's a size disparity and someone's just across the room from you, maybe yelling at you, saying, I'm going to get you, a jury may not find that to be an imminent threat, but the situation changes if there's a size disparity and that person is inches away from you getting ready to punch you in the face.
Mhm.
So it really depends on the specific facts of the question. I know lawyers love to say it
It
depends,
depends.
but it really does when analyzing reasonableness.
Yeah, one recent high-profile case that addressed the kind of disparity in numbers would be the Apple River stabbing case, I believe in
Hmm.
Wisconsin. Yeah, it happened in Wisconsin, and this was numerous assailants that were much younger than the defendant in that case, all kind of taking their turns punching him in the face. There were other factors that were really important, such as the fact that he had a very serious pre-existing medical condition. So there was very much an argument. Now, ultimately, the defendant in that case was convicted. The judge found that his use of deadly physical force, a knife in that case, either exceeded immediately, in other words, by the very first stab, or at least by the third, or whoever, however many people, that it was no longer imminent at that point. But there is a very strong legal argument that when somebody is surrounded and maybe they have a size disparities, age disparities, pre-existing medical conditions, a good savvy lawyer can definitely argue that this equals all the sum total of all these things equals deadly physical force, and using deadly physical force in response is completely reasonable. So it's one of those things. And remember, all we're doing, and we reiterate this in the reasonableness video that Mark and I recently did. All we're doing is reading the black letter of the law
Hmm.
and making predictions based upon cases we've seen and what the law says. But at the end of the day, the jury is the one who decides. The jury, I mean, all we can do is predict what a jury's going to find reasonable.
And sometimes I feel like juries make the wrong
And
decisions.
in this case, in the Apple River stabbing case, I thought they made the wrong decision.
I agree.
But my opinion doesn't matter there because it's up to the jury. I mean, a lot of legal scholars had this one wrong. But, there was another interesting question that I recently saw when we were talking about verdicts that we disagreed with. Somebody was saying, well, hold on, you guys are saying the jury got it wrong. Is it ever even possible? Is that definitionally possible, basically, is what they were asking, because what the jury says goes at the end of the day. So it's kind of nonsense to say that the jury got it wrong. This is a fair point
Hmm.
because the jury gets the say at the end of the day. Even could get so far as nullifying the law if they wanted to nullify the law, and they
Hmm.
get the final say at the end of the day. So, I mean, it's a very good point. Whenever you're hearing attorneys like us or anybody on the internet or scholars or even judges, when they're talking about these things, trying to predict, all we can give you is our best guess based on our experience in the black letter of the law. The jury has the final say.
Okay, well, let's dive into the next question. Okay, it looks like Win 52D3 or 52D says if it's 3 a.m., your alarm is blaring and you are yanked awake and see a dark shape in the house. You can barely see straight from sleep and you have to act. What is reasonable here?
Oh, this is a
I
fun
feel like I'm in
question.
the moment right
I
now. It's
know that was
happening to me right now.
Win52D gave a very descriptive thing there. Yes. So 3 a.m., alarm blaring, wake up, and there's a shadowy figure in the room with you. Once again, it falls in the exact same category as the last question, which is you're asking us to predict a reasonableness analysis. However, with this particular question, there's some interesting bright line rules at play here that weren't present in the previous example.
Hmm.
One of which being the fact that there's somebody who has potentially trespassed into your home, or importantly, that you as a reasonable person would believe that somebody has trespassed in your home. So there's kind of that reasonable mistake of fact going on here too.
Exactly, because I was thinking about a situation where what if it was your wife or husband getting up in the
Hmm.
middle of the night to get a drink of water? You hear the alarm blaring, it's unusual, but maybe they accidentally set off the alarm while they were getting that drink of water in the
Hmm.
middle of the night. If you then go ahead, shoot your significant other, thinking it was an intruder, we can still potentially argue self defense in that situation. It's still a question of reasonableness for the jury, but we can argue mistake of fact, like you just said. If you reasonably believed that that was an intruder, you still have that option of self defense available to you.
Yeah, reasonable mistake of fact, which exists in all 50 states, is one of my all time favorite doctrines in the criminal code. And I say that because, and just to explain what it is first, it basically says even if you're wrong about the facts, even if it turns out you were just dead wrong and mistaking about the facts, if a reasonable person would have believed the same thing as you, then we don't punish you criminally for that. That's a full
Mhm.
defense on any affirmative defense. And the reason why I love this doctrine so much is I think it's a really simple and pretty elegant way of sorting out who belongs in the criminal justice
Exactly.
system. The purpose of the criminal justice system is not to punish people with the right things in their head. We want to
Mhm.
punish people with the wrong things in their head. There was a very famous instance of a reasonable mistake of fact recently in the news with the taco shooting case, the taco shop shooting case in Houston, where somebody came and robbed the taco shop and collected wallets, and the good guy in that case shot the robber, and then kicked his gun away from him and inspected the robber's gun. It turned out it was plastic,
Mhm.
and he thought he was in big trouble. In fact, he fled the scene because he thought that he was sure that because he just shot somebody with a plastic gun, that means it was big trouble for him. But in fact, the grand jury correctly said, no, there's no charges here because any reasonable person, it wasn't an orange tip on the gun, it wasn't
Mhm.
multicolored, it was deliberately brought in by the bad guy to appear as a dangerous weapon. And so the grand jury made the right decision there. They said, no, no, any reasonable person would have thought that this was a firearm.
Yeah, it's definitely a good area of the law because without it, we'd be placing people in that situation with hesitancy. They'd think, okay, maybe I shouldn't shoot this person because what if it's a toy gun? I can't tell it's a toy gun, but what if it is one?
Yeah.
So I think it's definitely a great defense that we have in our repertoire here that we can use.
Yeah, and I give the example because it's based on a real case that I had one time, and it's just I always use it to kind of illustrate this concept to people. Is imagine you see a woman running down the street, and you see somebody jump out of the bushes and aggressively grab her and start wrangling her to the ground and everything like that. The good Samaritan in you might kick on at that point, and you might
Hmm.
run over and punch the guy in the face. And then it turns out you got the woman is a dangerous fleeing felon, and the person who just jumped out of the bushes was some sort of law enforcement who had a warrant or some sort of right in order to perform an arrest of this dangerous fleeing felon. You just made a big mistake there. Maybe you made a huge mistake. Maybe you punched the guy in the jaw so hard that it permanently disfigured him for the rest of his life. Um, the whole point of reasonable mistake of fact is, yeah, that sucks that that happened, but this guy had the person who punched the guy who jumped out of the bushes wrangling this woman, that person had the right thing in their head. We don't want that person in the criminal justice system. Now, whether you were negligent and you may be responsible for civil damages, that's a different question. That's hashed out in the civil court with different burdens of proof that don't involve jail time and permanent records and things like that for the most part. So, yeah, I mean, the whole idea of reasonable mistake of fact is to sift out who belongs in the justice system. But to return to this awesome question, not only could you possibly be mistaken about who it is, say it is a bad guy. There's additional bright line rules that we draw in the law for when somebody has done a forcible entry or are
Hmm.
trespassing in an occupied house. That actually creates a presumption that somebody's reasonable.
Yeah, and it could also potentially be a crime prevention argument, maybe not even a self defense argument at all, that you're preventing the crime of a burglary in this case by pulling out your firearm.
Yeah, absolutely. And so, once again, it's all going to come down to what a randomly selected jury of your peers in that jurisdiction are going to think is reasonable. But if you can get a jury instruction, because your state and all states do, if you can get a jury instruction that says something to the extent of, ladies and gentlemen of the jury, this is the judge talking to the jury. Ladies and gentlemen of the jury, just want to let you know, in this case, there was a forcible entry into an occupied structure. Therefore, in shooting this person, the defendant is presumed to be reasonable. If you can get that jury instruction, you're in very good shape. So,
Hmm.
all right, guys, let's see what else we got. Part one. Oh, okay. It's a two-parter. Awesome. You want to read this one, Rachel?
Yes, you mentioned in a previous self defense video that in Arizona, the government has the burden of proof in self defense cases after the defense puts forward a little proof. And then part two, what is a little bit of proof?
Yeah, great question.
What element has to be first proven by the defense?
You want to tackle this one?
Yes, so in these types of cases in Arizona, the defense has to provide what's called a modicum of evidence, which is a word
Itty bitty.
modicum is a word I've never used in my regular life. um, but in a legal
Could I have
sense,
just a modicum of sugar in my coffee, please? Yeah, who uses these crazy lawyer words?
definitely not me. But in a case like this, it just has to be any little bit of evidence. And this could be something like your own testimony, could be the modicum of evidence required. It could be an independent witness's testimony. It could potentially be some video evidence as well. But the important thing is, and this really separates justification defenses in Arizona from some other affirmative defenses where you have to bring forward a preponderance of the evidence, a much higher standard. It's really great because then the state has to prove beyond a reasonable doubt that you did not act in self defense, which makes the state's job a little bit harder.
Absolutely. In those jurisdictions, it shifts the burden over to the state, and they've got to prove it as if it's an element of the crime, right? Because
Hmm.
the state already has to prove every single element of the crime beyond a reasonable doubt. So when you claim the self-defense and the burden switches in that affirmative defense jurisdiction to the state, that's one more element that they got to prove. They got to prove you did not act in self-defense. So yeah, a modicum is just anything, really. It can be, and oftentimes it's as simple as you just pointed out. It's just the defendant asserting that they acted in self-defense.
Because sometimes, in some cases, that's the only evidence you're going to have is your own testimony. If it's a situation where it was just a one on one, there's no video, no photos, the other person won't testify. It may be up to you to present that evidence yourself. And in Arizona, for example, they want people to have that opportunity to bring that defense without it being too high of a burden.
Yeah, and there are a lot of jurisdictions that share that protection, that kind of enthusiasm for protection for self-defense statutes throughout the country. Most of them, frankly, do.
Hmm.
Most jurisdictions do shift the burden over to the state to prove that they didn't act in self-defense beyond a reasonable doubt. But I think a really important thing to note here is that there's this kind of a selfish reason that the court wants to give you the jury instructions that you're asking for, which is they don't want the case coming back on appeal. And any lawyer will tell you that when there's a defense that you're trying to assert for a case, it could be the difference between whether your client gets convicted or not convicted. Like, imagine if there was a shooting case and you couldn't, or and like you believed you acted in self-defense, and there's no factual dispute that you shot the person who was coming at you, and the judge said, "Sorry, you're not allowed to argue self-defense for whatever technical, hyper-technical reason." This is a big deal, and
Hmm.
an appellate court would take a look at this. And very, very likely, I mean, getting jury instructions and getting the judge to give the instructions of your choice, this is what I would call fertile ground for an appeal, fertile ground for an appellate issue. If the judge denies us an instruction that we want, oh,
Oh, you
collecting,
bet.
we are collecting those appellate issues, and we're going to complain about it if our client were to get convicted to the appellate court. And appellate courts very, very often will reverse the whole conviction and say, I need a new trial. The trial court screwed up. You guys need to redo this thing, and don't deny them their right to at least argue. They're presumed innocent. Let's not forget that.
Hmm.
And so you shouldn't be denying them their right to argue this to a jury. So judges are very liberal in giving these types of instructions.
Yeah, judges don't like being overturned.
No, no. And yeah, so if you think it's just the judge doing it out of the goodness of their own heart, no, they don't want the case coming back after getting slapped by the appellate court. So,
Mhm.
all right, what's next? Oh, another two-parter. I'll take this one. Strong Mountain 7446. Let's suppose you are not the aggressor and you attempt to de-escalate and even withdraw from a situation but are unable to. As a result, you display a firearm holstered at your side, but the aggressor charges in on you. Is it reasonable to believe that if the assailant obtains the firearm, you could be killed? Lots of great things here in these questions. I like how each one of these questions, these last three, well, without the modicum question, but all these kind of hypotheticals, they're all asking about reasonableness, but each one of the questions is kind of implicating a different interesting doctrine of reasonableness.
Mhm.
What are your thoughts? Do you have any initial thoughts on this?
Yeah, so in this situation, there's a couple things here. The first is that you mentioned that you attempt to de-escalate and you even attempt to withdraw first. We were talking about this before we started filming today. We love these situations where
This is on
people.
my wish list as a
Mhm.
criminal defense attorney. I want to see, like, we want to see an escalation of force. We want to see an attempt at avoidance of force. Remember that when we're arguing whether somebody acted in self-defense, we're asking if it was reasonable, and part of that reasonable analysis is it proportionate to the threat you were looking at? Was the threat imminent? I mean, it is so strong to be able to argue to a jury. Before my client discharged that round, he did everything he could to try to escape.
Mhm. Now, I don't want people, retreating if it would be dangerous to do so.
Mm.
But if it's safe to retreat, it makes our job a lot easier. I'll take it.
Yeah.
Um,
We're not asking any homeowner if somebody breaks in to jump through a glass window off the second story to get away. That is not what we're talking about.
exactly, but in this case, it really helps us sell reasonableness to the jury. If the jury knows you were trying to look for a way out and basically your choice of using deadly physical force was not your first choice, the jury will see it as much more reasonable that you attempted other options before exercising that more drastic option of deadly physical force.
Hmm.
The next thing I think is a good thing to point out here is the Strong Mountain asks, as a result, you display a firearm in some way, but the aggressor charges in on you.
Hmm.
And I think, again, we dive into reasonableness here. Once someone's charging at you, it really makes it more likely that the jury's going to find that it was reasonable. Again, we're just predicting here what a jury might find. But when I'm analyzing a case, if I see something where the aggressor is actually charging at you, I already know that I'm going to have a much stronger argument than if the aggressor was hanging out in the other side of the room. Because again, another point we like to, beat to death here is that the threat really needs to be imminent.
Mhm.
And something like charging really makes the threat that much more imminent.
Absolutely. And like on the subject of escalation of force and retreat, like yeah, you shouldn't be trying to you don't need to take this doctrine to the limit where you're now endangering yourselves
Hmm.
or other people. That is not what is required from you. And I think of it, we've had cases, for example, home invader comes in, client announces, I have a gun, get out. Client maybe displays the gun. Client attempts to go to the door, but maybe that person is too in front of the door and they're blocking them. They've now made an attempt, they've announced, they've shown the firearm, then they discharged around. This is what we're looking for. We want to see that escalation of force. We want to see whatever attempts you can to reasonably escape. We don't necessarily need those things, but they're on our wish list as criminal defense attorneys when we're arguing to the jury. And all this is to say, ladies and gentlemen, he had no other choice. He did this, he did this, he did this, and none of it stopped the imminent threat. So, yeah, I think those are all really important. But something that I was a little bit unclear on in this question and what the questioner was asking, I wasn't clear on what type of force they're repelling, right? Because if they're imminently charging at you with fists and you pull out a firearm at that point and blow them away, while you have the imminency required in the equation of reasonableness, the proportionality screwed up at that point,
Hmm.
potentially anyway,
Potentially.
without other factors. But just one for one in this hypothetical in a vacuum of deadly physical force versus ordinary physical force. It doesn't matter that it's merely imminent; it has to be proportional. So. Hopefully that helped with kind of this, but I guess the point of the question that I really wanted to highlight is if you can do an escalation and it's ineffective and then you have to discharge deadly physical force, you've just helped your defense attorney a lot.
And another point that we haven't really mentioned yet in this question is that they say you display a firearm in some way. So maybe not actually firing the gun or maybe not even just pointing the gun at someone, but what if it is really just holstered at your side?
Hmm.
What if it's more of what in Arizona we call defensive display of a
Hmm.
firearm? What are your thoughts on that situation?
Yeah, in the defensive display statutes, there are a bunch across the United States, and they're all kind of a little different.
Hmm.
What constitutes a defensive display can vary between jurisdictions. For example, I had a case one time where my client was charged with disorderly conduct with a firearm because he simply informed a person who was threatening him that he had a firearm. He said, "Hey, you don't want to mess with me. I got a firearm." Then that person called the police and they arrested me. We were able to get it dismissed, but it's what counts as a defensive display is very different. Now, another great thing about defensive display is that you can use it in most jurisdictions to repel ordinary physical
Hmm.
force. Okay, so prosecutors make a big deal out of if you point a firearm.
Hmm.
If you point a firearm, even without the finger on the trigger, even without a round in the chamber, you point the firearm, they're going to charge you very often with a very serious crime. Whereas if you and that when you point it, by the time you're pointing it at your assailant, you better be looking at deadly physical force. You
Hmm.
better be looking at imminent deadly physical force if you point it, just as a general rule of thumb. However, a defensive display. Imagine you either pat the firearm, inform them of the firearm, have the firearm at the low ready, maybe have the firearm pointed up in the air. There's all kinds of different ways that you can defensively display a firearm. Sometimes just racking the shotgun can get the job done. We've
Hmm.
had cases like that where that scared away the bad guy. But these all could be defensive displays. Most defensive display statutes throughout the United States says, okay, if you're looking at ordinary physical force, somebody's coming with you, and then you use the defensive display with the firearm, as long as you're not pointing it at them or it's imminent that you're threatening deadly physical force, we're fine with it. We're satisfied, say most jurisdictions. Of course, make sure, huge disclaimer here, guys, make sure to know your state's gun laws.
Hmm.
So important because not all states are as friendly to guns. You guys know what I'm talking about if you live in a what I would call maybe an anti-gun or less gun-friendly state. Make sure to read. Every competent gun owner should anyway. read all
Right.
the relevant self-defense statutes, defense of a third party, crime prevention statutes. So important.
But even in these self-defense friendly states or gun friendly states, we see people that exercise defensive display of a firearm that we would say that's a good defensive display. They made the right, reasonable choice in this decision. We still see people in this situation getting charged with a crime. And that's why it's smart to have, attorneys on retainer because in these unexpected situations where you were being a responsible gun owner, but the state, maybe an officer, a prosecutor disagrees, we still have your back.
Yeah, that's a really good point. And in fact, that illustration, the hypothetical or the case that I just gave,
Hmm.
was exactly that.
Yeah.
It turned out the prosecutor agreed when we threatened him, with the jury trial. He was like, okay, 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 I'll dump the case. But innocent people who did the right thing get charged all of the time. And some prosecutors are more avid about prosecuting these types of cases than others.
Hmm.
And they almost always involve, when there's a firearm involved, almost always involve prison on the line, permanent records, loss of firearms rights, all the social stigma associated with being a felon, and problems traveling, serious, serious cases. And oftentimes, prosecutors use this disparity of bargaining power, I'll call it, knowing that they know
Hmm.
that your client knows if they go to trial and lose, they're looking at so much time. And so they will use this disparity of bargaining power to get your client to plead guilty, right?
Hmm.
They'll put the screws on them and say, all right, sure, yeah, you have a defensible case, but if you go to trial and lose, you're looking at a decade or more in prison. How about I offer you this, that, or the next thing? And innocent people I see get convicted for different reasons in the justice system. So, best to avoid the whole thing from the get go. Best to be armed with an attorney ready to go in the beginning. So, there you have it, folks. Let's see the next question.
Okay, Mr. Cop Tom. I've heard you might have an option to request a trial by judge only and not a jury. Is that a thing? And if it is, which might be the best way to go? I'm going to throw out one of our favorite answers again. It depends, but you definitely can request a trial by judge. Just because you request one doesn't mean you're going to get one, of course.
Hmm.
But there are some circumstances where I would recommend to a client that you might want to consider a trial by judge, which we like to call a bench trial.
Hmm.
One situation that I would consider requesting a bench trial in is if our argument is really a very technical, legal argument. And I'm not saying that a jury might not understand that argument, but juries have a power called jury nullification. And so I've seen in some cases where a jury might struggle to make that choice if it's based on a very technical legal argument. The jury might say, I don't want them to get away with it just because of this little legal loophole. I
Hmm.
know they did it. And so the jury might say, even though the law's on their side, um, I'm gonna nullify this and find them guilty. But if we have a really technical legal
Or
argument,
they might just be confused by the
yeah, they
technical
could
argument.
just be confused.
Yeah.
That's a situation where I'd want to go in front of a judge.
Yeah, I totally agree with that. When we're making a nuanced legal point, I mean, to have a trained judge there who, assuming they're going to follow their oath of office, are going to put aside the passions and objectively and calculatedly follow the law and make a ruling that's consistent with the law, that's the type of case that I want for a bench trial. But a jury might be more favorable to you if you want to argue a lot of mitigation in the
Hmm.
case. And mitigation, for those of you who don't know, is just another one of those fancy lawyer words. And all it means is stuff that shows that they're a good person, or stuff that shows the context, or stuff that can tug at the heartstrings a little bit and maybe make the jury want to take it easy on your client. Jurors, they're not trained lawyers. They are human beings, and in doing, in being just kind of lay people, they're affected by their emotions, and oftentimes that can be in the best interest of your client, especially if you have a very sympathetic client, a client who has a tough background, tough upbringing, tough life that is introduced as evidence. Things like that can be more effective in front of a jury.
Yeah, and this is a question we discuss on pretty much any case that we're thinking about going to trial on. It's something we discuss, what are the pros, what are the cons, and there's some cases, frankly, where it's kind of a close call whether we want to go with a bench or a jury trial.
Hmm.
So we always talk about it as a team before we make that decision.
Yeah, another type of case that maybe a jury is an advantage here is if you have a case where the circumstances for your client were really scary.
Mm.
And you can, as a good defense attorney, it's all about telling a story.
Hmm.
You want to paint a picture for the jury. You want them to step into the empathetic shoes of your client. And you want them thinking in their head, geez, what would I have done in that situation? I think I would have defended myself too. I think I would have
Hmm.
used my firearm in that situation too. Even if it was disproportionate, for example, like if in this case, a cold and calculated legal analysis might be bad for your client, where the judge is saying, yeah, I feel bad for him and everything, but he used this amount of force and this amount of force, and the statutory law says this, that, and the next thing. Having a jury with that human element, if your client went through a traumatic or scary or trying situation, that could be what you need to get the not guilty.
And there's actually some cases that have to be bench trials.
Hmm.
For example, for firearm cases in particular, it would be more rare that would be required to be a bench trial, but there are certain misdemeanor crimes that are only bench trials, and you don't necessarily have that right to trial by jury. So that's another consideration.
Yep, excellent point. All right, let's see another one up there. All right, Charles Whalen 7332. Can a judge hold a juror in contempt of court and jail him or her for engaging in juror nullification or of overruling a law? Okay, interesting question here. So, to the question of whether a juror can be held in contempt or anything, or jailed or something for engaging in jury nullification, there's a threshold question even before that, which is how did the judge find out? Because the judge is not allowed to inquire about anything that occurred during
Yeah. Jury
deliberations.
deliberations are supposed to be in secret.
Yeah, that's absolutely right. And so if a judge found out that jury nullification occurred in that jury room, it's because somebody told the judge outside
Hmm.
of that. Somebody kind of broke the confidentiality of the jury deliberations and said there was jury nullification that occurred. But I have never, as a practical matter, never heard of anybody being held in contempt, anybody being jailed.
Neither have I.
Yeah, I mean, I've never heard of that whatsoever. What I have heard of, which is relevant here, is verdicts getting overturned because there are concerns about the jurors intentionally and willingly being unwilling to follow the law. This
Hmm.
type of thing could be raised. And so you got to think about it like this is if you felt as a jury, if you felt strong enough to nullify, to basically go against the law and judge the law as wrong and reach a verdict where you're engaging in jury nullification, you're not being very protective of that verdict and those principles that you stood on when you go around blabbing about it.
Hmm.
Because if the opposing side finds out within a period of time where they're still able to appeal, that could be a problem. Right, because that could cause a verdict to be overturned or there to be a new trial or something like that. So that I have heard of.
Hmm.
Oh,
Let's go to the next question.
all right, what do we got next?
So, at Church Mouse asks, if we keep our mouths shut, we won't say anything about evidence or witnesses. What would happen then? Well, that's the point. We don't want you to say anything about evidence or witnesses until you've had a chance to talk to us.
Mhm.
And in our AOR program, we give all of our clients our emergency hotline, which is 24/7. So in this situation, where you have to make that decision, do I need to make any statements? Don't worry about it. We'll help you make that decision.
Right.
Call that emergency line. I'll wake up in the middle of the night. I don't mind to answer that question. But there are
You just
some.
took one late at night while we were at the NRA
Yeah, at the
conference.
NRA conference. So, even at the NRA conference where I was having a bunch of fun, I was ready. I love getting those calls.
Yeah, they're exciting.
Yeah, they're very exciting calls.
And I'm happy to help clients when they come through. You kind of get in game mode and you're like,
Right?
yes, it's time to, it's time to handle this situation.
Definitely. And there are some times where we get a call and people have followed our advice, or as Mark likes to say, just shut up. They followed that advice, and we get to talk with them about what has happened. And sometimes we come to the conclusion that maybe they do want to make a statement, or maybe we want to make a statement on their behalf.
Mhm.
So just because we want you to just shut up until you talk to us doesn't mean we're keeping everything in the case a secret forever. We just want to make sure that you say the right thing, because often in that self-defense situation, your mind is going a million ways. It's a stressful situation. I think it's not surprising that you may say some things you don't mean, or you may accidentally say something that at the time feels fine, but later on, it's something that an officer or prosecutor can twist to fit a different narrative
It's
potentially.
it's like the worst time you could make a statement when you're under that sort of psychological pressure from what just occurred. And Rachel, you make an excellent point, which is that every case is so different.
Hmm.
I mean, people ask us as attorneys to give general advice all the time. There's some general advice we can give. We can read you the black letter of the law. We can give you the different principles of self-defense. But at the end of the day, every case needs its own attention.
Hmm.
Every single fact pattern is different. What's smart to do, what's best to do. While just shut up is always a good
Hmm.
idea. What happens next? What statements will be made? Whether to make a limited statement, things like that are really important and really fact specific. And we can't tailor your handcrafted defense until we've had a chance to talk to you and figure out everything that happened.
Hmm.
So many times we've said, Rachel, that the worst evidence in the entire case has come straight from our
Right?
client's mouth when they decided to try to talk to the police and say brief things about evidence or facts.
Right, because I've had some cases where people have made statements and it's ended up not being a big deal. We're still able to argue our defense, we're still able to get the case potentially dismissed. But I can say that those few situations are heavily outnumbered by I can't say how many times we've met on a case and we say,
Ah.
what if they hadn't talked?
He
What
didn't close
if?
his mouth. Ugh.
And the thing is, you can't take back something you said, to an officer at the scene. But if there was just silence, we have all the opportunity in the world in that situation to craft a statement with you and to make sure that what's being expressed to the prosecutor is not something that was filtered through the brain that was going through a really stressful situation in the moment.
Yeah, there's a lot of public misconception about what happens when you remain silent.
Hmm.
When you remain silent, not only can it not be used against you, if it goes to trial, the prosecutor can't even comment on it, can't even
Hmm.
bring it up. And if you want proof of that, watch the Kyle Rittenhouse case. There's a pretty amusing viral video where the judge bitch slaps the prosecutor for even mentioning the fact that Kyle Rittenhouse remained silent after his arrest. So, yeah, the prosecutor can't even mention or draw any sort of adverse inference by the fact that you invoked your Fifth Amendment right to remain silent. So there's that first and foremost. It's just so important to remain silent. I mean, another huge point here is that people will ask us, like, should I at least say I was in fear for my life? No, the answer is no. And the reason the answer is no is because in every single state in the United States, there are a number of criminal defense statutes that have nothing to do with being in fear for your life that might be applicable to your case. Could be a defense of a third party. Maybe you're in fear
Hmm.
for somebody else's life. Could be one of these crime prevention statutes that we were talking about earlier. Could be some other justification. You might be in a wacky
Hmm.
jurisdiction like Texas, which actually allows you to use deadly physical force in some circumstances to defend property. There's all kinds of different things here. And all you're doing by making that statement of, I was in fear for my life, is you're closing doors. You're
Hmm.
foreclosing your future defense attorneys from being able to argue everything or the thing that applies the most.
Exactly. And a situation I often think about and like use as an example for why you may want to shut up is, let's say you were facing a very real threat to your life and you exercised deadly physical force, you pulled out your firearm, you shot at the attacker. Police respond to the scene and you say, I was in fear for my life, they were attacking me. But the person that your bullet hit was a innocent third party.
Hmm.
That's a situation where you could still be held liable for that. And that statement, while it sounds good, could potentially be used against you because here you are admitting to the fact that you were in fear and that you were the one that shot that firearm. And that will be used against you in that criminal case. So it sounds good. It sounds like something you'd want to tell an officer, but at the end of the day, it will hurt you.
These insights, and that's an excellent point, Rachel. And these insights only come from criminal defense attorneys who have done hundreds of cases. If we sound jaded to you, it's just because we've seen everything under the sun. And when you
Hmm.
start to see patterns of which cases turn out good for the defendant and which cases go better for the state, you start noticing patterns of behavior of the clients and like who shut up, who said this, who said that, who acted like this, and just from our experience, it is best to just call us first. And that's one of the benefits. I mean, at the NRA conference, whenever we were meeting with members, we were asking them questions like, what's your favorite thing about the program? How can we improve? Everything like that. Very, almost unanimously, one of the main things people loved is I love the fact that I have a hotline where I can get an attorney on the phone within
Mhm.
minutes. That's the most important thing. To me, when I'm in a self-defense incident, I need to be talking to an attorney, not an insurance adjuster, not a club member, nothing like that. I want to be talking to an attorney within a few minutes. That's really important to people, and it
Mhm.
should be.
It should be because seconds or minutes can make a huge difference in a criminal case
Mm.
and what we're able to do in those situations. We have way more options available if we're able to be on the case from the first second after it happened rather than, days down the road for non-members. So it's a great aspect of our program.
Do we got time for one more, guys? Got
Okay,
one more? Okay, they're
one
giving us
more.
the thumbs up. Let's do one more. You want to take this one, Rachel?
Yes. Okay. So at Fisher Drywallin asks, in a road rage incident, if someone is physically challenged me and I point my gun at them without firing and they run away, should I report this? I live in a retreat state.
I love road rage cases. They're so interesting, mainly because most jurisdictions treat a vehicle, when driven recklessly or aggressively, as the same status as a deadly weapon, right?
Hmm.
A vehicle driven at somebody aggressively is, for all intents and purposes, you're firing a gun at
It's
that
like an
person.
aggravated assault.
It's an aggravated assault. Yeah,
Hmm.
we've seen it charged as that. We've seen our clients been victims of that before. And it's very interesting because once that vehicle becomes a deadly weapon, there's all kinds of interesting questions about what somebody can do in response to a threat.
Definitely.
I mean, what are your thoughts in general about like fleeing and how to respond to some sort of a threat like this?
In this situation, if I was facing this threat, where someone was coming at me with their car in an aggressive manner, it really does come down to in that moment, is my life on the line? Because if I feel my life is on the line, I'd rather be alive and facing a criminal charge than be dead and have not exercised self defense.
Hmm.
However, there's also the question of if I do take that step, I feel like it is necessary to protect my life, point my gun at someone without firing, and then maybe they drive away. Should I report this?
Hmm.
I think this kind of circles back to what we were just talking about a second ago. Why not just call your an attorney?
Yeah.
And if you have AOR, you had that option in that emergency situation to call an attorney. So after it happened, we can help you make that decision on whether or not to report it. Because once again, it does depend.
Yes, another excellent point, which it goes back exactly like you're saying to each case is different. And we have had so many cases where the clients took our advice before calling the police and said, what should I do? And we said, well, were there any witnesses? Did anybody else see it? Is anybody else in your car with you? Is anybody else talking? Okay, were there any cameras around? No, 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 no. Don't call the cops. We are advising you not to report this incident. And in many, many, many cases, it's turned out to be a big nothing. So,
Hmm.
yeah, and it's all sometimes there are times when you would report things to the cops and where we do want you to call 911 if we're confident that there were witnesses or that people knew about it or that it's likely to be reported or that it's the type of crime cops would expend resources on, because that's an important point. There's a lot of things out there that are reported that cops are like, I don't have the time to like drive around and look for a car kind of matching this description that they can't even give me a license plate for, looking for somebody who might be aggressive. No, sorry, we can't help you. So, we may say this is not the type of thing that we think that they'll expend the resources on, and it's likely to become a big nothing as a result. So, yes, another great reminder to always call your attorney if you're in this type of an incident.
And then another thing at Fisher Drywall noted is that he lives in a retreat state.
Mm.
So that's an important analysis. And I think that goes back to a few questions ago. We talked about, in those kind of situations, you need to realize if it's safe to retreat or not. So often in a retreat state, the law is that you have a duty to retreat if it's safe to do so.
Hmm.
You have a duty to at least attempt to retreat. So in that instance, if there is an opportunity to safely retreat, it is better to safely retreat before, pulling out your firearm and using it in self-defense in that situation. However, if it's not safe to do so and you have to pull out your firearm, like we said, call us. We'll help you make that decision on whether or not to report it. Because in a situation like this, the police may find that you were out of line and pointing your gun, or they could find that the other guy was out of line and driving his car in an aggressive manner at risk for your life. And we could help you kind of sort through that analysis. Because when you're in that road rage situation, it may be harder for you to make that determination of whether you were in the right or wrong.
Hmm.
And we can help you, get some perspective on that situation and help walk you through those next steps.
Yeah, a couple of things particularly about this question. First of all, he goes straight to pointing the gun. Not a fan of this. Refer to our conversation we had earlier about an escalation of force. While not always necessary, it's definitely on our wish list as criminal defense attorneys. For example, I've had cases where a client was able to defer somebody by simply placing it on the dashboard very visibly, kind of like, here it is, I have it,
Mhm.
back off kind of thing. I've had clients display it, maybe, hold it up in a way that it's kind of the profile view of it and like, take a look, that's what I got for you. And so my preference is to do anything you can other than point it, because remember, prosecutors take it really, really seriously when you're pointing. You're likely in most jurisdictions to be charged with a more serious crime if you point it than if you defensively display it in a non-pointing manner. So there's that. Second of all, just in my experience from having done many, many cases where it starts as a road rage and it ends in a shooting, and I've done several actually pretty high-profile cases. There's a couple in particular in the state of Arizona that I have done that involved the a road rage incident, which then turned into a homicide.
Mm.
I can just tell you this from experience, and this kind of goes to what we talk about all the time. If you pull out a firearm, expect to be prosecuted.
Yes.
Definitely expect to be prosecuted, even if you're innocent, even if it turns out that it's going to be completely defensible. Because what I can tell you is, when it comes to these types of incidents, somebody's driving a car at you recklessly and then you return fire and shoot them and maybe kill them. A prosecutor is going to err on the side of charging the person who fired the gun. And the
Mhm.
reason is it's extremely difficult to prove that they were driving it in a way that was so imminent. That they're posing imminent deadly physical force. The
Mhm.
prosecutor is going to err on the side of saying, I think I can convince a jury that that didn't happen in this case. And so, what and unless it's like all on video, right? Like
Right.
some people go around with dash cameras, but dash cameras don't capture everything either.
Mhm.
So just expect any time that you pull out a firearm that you're going to be prosecuted. And the question in your mind should always be, is what's about to happen to me right now worse than being prosecuted? And we've talked in many of our videos what it looks like to be prosecuted. It's a living nightmare for many, many people. And it's stressful and expensive, unless you got AOR. But you're constantly worried about your future. You're constantly worried about everything. Your life is topsy turvy,
Mhm.
and so unless what's going to happen to you if you don't pull out the firearm is worse than that, you shouldn't pull out the firearm. So what goes in that category? Things like, am I about to die?
Right.
That's worse than being prosecuted. How about my loved one or a third party that I care about? They're about to die. That's worse than being prosecuted. But other than that, it's tough to imagine too many things that are worse than being
I mean, I'd
prosecuted.
rather get punched in the face than be prosecuted. So,
And I'd certainly rather be disrespected or
mhm.
something like that than be prosecuted. So, I think that's a good one to end on. Any
Yeah.
final thoughts you have on today's stream, Rachel?
Well, I do have one final thought, because the whole reason I wore this polo today is because, again, marketing had a list for us and they wanted us to show off these really awesome polos. Unfortunately, my beautiful hair was covering the logo the whole time. But you can go to our website, check out these polos. They're really comfortable, they look really sleek. So I encourage you to check those out as well.
There's also some girly wear coming very soon. Rachel, I know you were clamoring for some. It only seems appropriate, since we're the host of the Lore and Liberty Armed and Fabulous shows, to also have some for our female viewers so they can rock some badass attorneys on
I got
retainer.
your back, women.
There you go. All right, guys. Thank you so much for tuning in to our live stream today. It was a blast doing this for you. Go and check out attorneysonretainer.us. Learn all about our self-defense program and what it can do for you. Also go to attorneysforfreedom.com. Learn all about our law firm, our defense, and what our philosophy is when we represent our clients. We really, really care. It's not just a slick name, Attorneys for Freedom. This is our philosophy and how we practice law. So go and check it out there. If you enjoyed this, you can like the video down below. Make sure to leave us some comments. Give us some cool merch ideas. Share it with a friend if you liked it, and subscribe to the channel. Until next time, my friends, this has been attorney Andy Marcantel and attorney Rachel Moss and the Attorneys for Freedom. Peace.